Part 2. Mediation of disputes. Submission to mediation. 63. 1. A party to any agreement may with the consent of the other party submit any dispute arising out of that agreement to mediation by an institution or a person agreed on by the parties. 2. A submission to mediation may be made by writing, telephone, or other form of verbal communication, fax, telex, email or any other electronic mode of communication, and shall briefly state the nature of the dispute. 3. A submission to mediation through telephone, or any other verbal mode of communication shall, unless the parties agree otherwise, be confirmed in writing and shall state the names, addresses including email addresses and telephone numbers of the parties, and in brief the nature of the dispute. 4. Mediation proceedings commence when the other party accepts the invitation for mediation. 5. An acceptance of an invitation for mediation may be by a letter, telephone, or other form of verbal communication, fax, telex, or email or other mode of electronic communication. 6. An acceptance by telephone, or any other verbal means shall be confirmed in writing, but a failure to confirm an acceptance in writing shall not invalidate the proceedings. 7. Failure by the other party to accept the invitation to mediation within 14 days after receipt of the invitation, or within the period of time specified in the invitation, shall be considered to be a rejection of the invitation to mediation. Reference to mediation by court. 64. 1. A court before which an action is pending may at any stage in the proceedings, if it is of the view that mediation will facilitate the resolution of the matter, or a part of the matter in dispute, refer the matter, or that part of the matter to mediation. 2. A party to an action before a court may, with the agreement of the other party and at any time before final judgment is given, apply to the court on notice to have the whole action or part of the action referred to mediation. 3. A reference under subsections 1 or 2 shall state a. The nature of the dispute, b. The monetary value of the claim, if any, c. The reasons for the reference, and d. The remedy sought, and shall have attached copies of the pleadings and any other documents the court considers relevant. 4. A reference under this section shall serve as a stay of proceedings of the court action. 5. Where a reference leads to settlement of the dispute or part of the dispute, the settlement shall be a. Drawn up and filed in the court, b. Recorded by the court as a judgment of the court, and c. Enforced by the court as its judgment. 6. Where the reference does not lead to a settlement, the court shall continue with the proceedings from the point where the reference was made. 7. A reference by a court shall specify the time within which a report on the reference shall be submitted to the court. Number of mediators. 65. 1. Unless the parties otherwise agree, there shall be one mediator. 2. Where there is more than one mediator, the mediators shall act jointly. Appointment of mediator. 66. 1. The parties to a mediation may appoint any person, or institution the parties consider acceptable to serve as a mediator. 2. Parties may request the assistance of a suitable institution or person in the appointment of a mediator, and may in so doing request the institution or person a. to recommend the names or provide a list of suitable persons to serve as mediator, or b. to conduct the mediation. 3. Parties to a mediation may adopt the mediation rules in the 4th Schedule to this Act. Mediator with interest. 67. 1. In recommending a person to be a mediator, an institution or person shall have regard to the independence and impartiality of that person, and take into consideration the background of the parties. 2. An institution or person that is requested to recommend a mediator shall not recommend a person to serve as a mediator, if that person has a financial or personal interest in the outcome of the dispute. Disclosure by mediator. 68. 1. A person appointed a mediator shall, before accepting the appointment, disclose any circumstance relating to that person that may a. Create a likelihood of bias, or b. Affect the conduct of the mediation. 2. A mediator shall promptly disclose to the parties any circumstances that arises during the mediation, which is likely to affect the a. Impartiality of the mediator, or b. Conduct of the mediation. 3. Parties to a mediation may replace a mediator who makes a disclosure under subsection 1. Termination of appointment for delay. 69. The parties may replace a mediator who without reasonable cause fails to a. Start work within the period agreed by the parties, or b. Operate within the ground rules of the mediation. Filling of vacancy in mediation. 70. The parties may appoint another mediator to replace a mediator who is unable to perform the functions of a mediator. Representation in mediation. 71. 1. A party to a mediation may be represented by a lawyer, an expert, or any other person chosen by the party. 2. A party shall communicate, in writing to the mediator and the other parties, the name, address and the extent of the authority of any representative within 7 days of the representative's appointment. Date, time and place of mediation. 72. 1. A mediator in consultation with the parties shall determine the date and time of each mediation session. 2. Subject to the mediator choosing a convenient place, the parties shall determine the place for the mediation. Identification of issues in dispute. 73. 1. Not later than 8 days before the first mediation session, or within such period of time as the parties may mutually agree upon, each party shall present to the mediator, and the other parties a memorandum setting out the party's position with regard to the issues which require resolution. 2. The mediator may request each party to submit a written statement of that party's position and the facts and grounds in support of that position, supplemented by any documents and other evidence that the party considers appropriate. 3. At any stage of the mediation proceedings, the mediator may request a party to submit additional information, as the mediator considers necessary.
Powers of mediator. 74. 1. A mediator shall in an independent and impartial manner do everything necessary to help the parties to satisfactorily resolve their dispute. 2. A mediator may conduct joint or separate meetings with the parties and make suggestions to facilitate settlement. 3. A mediator may, where necessary, and if the parties agree, to pay the expenses. Obtain expert advice on a technical aspect of the dispute. 4. A request for the services of an expert may be made by the mediator or by one party with the consent of the other party. 5. A mediator shall be guided by principles of objectivity, fairness, and justice, and shall give consideration to, among other things, the rights and obligations of the parties, the usages of the trade concerned and the circumstances surrounding the dispute, including any previous business practices between the parties. 6. A mediator may conduct the mediation proceedings in a manner that the Mediator considers appropriate but shall take into account the wishes of the parties, including any request by a party that the mediator hear oral statements, and the need for a speedy settlement of the dispute. 7. A mediator may end the mediation whenever the mediator is of the opinion that further mediation between the parties will not help to resolve the dispute between the parties. Administrative assistance. 75. In order to facilitate the conduct of mediation proceedings, the parties, or the mediator with the consent of the parties, may arrange for administrative assistance by a suitable institution or individual. Communication between mediator and parties. 76. The mediator may invite the parties to meet the mediator and may communicate with them orally or in writing, and may meet or communicate with the parties together or with each of them separately. Attendance at mediation. 77. Except where the parties agree and the mediator consents, a person who is not a party to the mediation shall not attend a mediation session. Disclosure of information. 78. Except where a party gives information to the mediator subject to a condition of confidentiality, when the mediator receives factual information concerning the dispute from a party, the mediator may disclose the substance of that information to the other party in order that the other party may have the opportunity to present any explanation which that other party considers appropriate. Confidentiality of mediation. 79. 1. A record, a report, the settlement agreement, except where its disclosure is necessary for the purpose of implementation and enforcement, and other documents required in the course of mediation, shall be confidential and shall not be used as evidence or be subject to discovery in any court proceedings. 2. A mediator shall not disclose information given in the course of the mediation to a person who is not a party to the mediation without the consent of the parties. 3. Without limiting the effect of subsection 1, a party to a mediation shall not rely on a. The record of the mediation, b. Statement made at the mediation, or c. Any information obtained during the mediation as evidence in court proceedings. End of mediation. 81. A mediation ends when a. The parties execute a settlement agreement, b. The mediator terminates the mediation proceedings for non-payment of a deposit under Section 88. c. The mediator, after consultation with the parties, makes a declaration to the effect that further mediation is not worthwhile. d. The parties jointly address a declaration to the mediator to the effect that the mediation is terminated, or e. A party makes a declaration to the mediator and the other party to the effect that the mediation is terminated. 2. A declaration under subsection 1 may be in writing or oral, but where a declaration is not written, the mediator shall record the declaration. Settlement agreement. 81. 1. Where it appears to the mediator that there exist elements of a settlement which may be acceptable to the parties, the mediator may formulate the terms of a possible settlement and submit them to the parties for their considerations, and after receiving the observations of the parties, the mediator may reformulate the terms of a possible settlement in the light of the observations. 2. If the parties reach agreement on a settlement of the dispute, they may draw up and sign a written settlement agreement, and if requested by the parties, the mediator may draw up, or assist the parties in drawing up, the settlement agreement. 3. When the parties sign the settlement agreement, the parties shall be deemed to have agreed that the settlement shall be binding on the parties and persons claiming under them respectively. 4. The mediator shall authenticate the settlement agreement and furnish a copy of the settlement agreement to each of the parties. Status and effect of settlement agreement. 82. Where the parties agree that a settlement is binding, the settlement agreement has the same effect as if it is an arbitral award under Section 52. Resort to arbitral or judicial proceedings. 83. The parties shall not initiate, during the mediation proceedings, any arbitral or judicial proceedings in respect of a dispute that is the subject matter of the mediation proceedings.
Role of mediator in other proceedings. 84. Unless otherwise agreed by the parties or required by law. A. The mediator shall not act as an arbitrator, or as a representative or counsel of a party in any arbitral or judicial proceeding in respect of a dispute that is the subject of the mediation proceedings, and b. The mediator shall not be presented by the parties as a witness in any arbitral or judicial proceedings arising out of or in connection with the dispute. Mediated upon. Admissibility of evidence in other proceedings. 85. The parties shall not rely on or introduce as evidence in arbitral or judicial proceedings, whether or not the proceedings relate to the dispute that is the subject of the mediation proceedings. A. Views expressed or suggestions made by the other party in the mediation in respect of a possible settlement of the dispute. B. Admissions made by the other party in the course of the mediation proceedings, or c. The fact that the other party had indicated that party S willingness to accept a proposal for settlement made by the mediator. Exclusion of liability. 86. 1. A mediator shall not be a party in any court proceedings relating to a mediation under this Act in which the mediator participated. 2. A mediator is not liable for any act or omission in the discharge of the functions of a mediator unless the mediator is proven to have acted in bad faith. Mediation expenses. 87. Unless the parties agree otherwise, the parties shall equally pay the expenses of the mediation, including the fees and expenses of a. The mediator, b. Any administrative assistance received, c. Experts called, and d. Any expenses incurred in connection with the mediation proceedings and settlement agreement. Deposits. 88. 1. The mediator may direct each party to deposit an equal amount as an advance for the expenses of the mediation referred to in Section 87, which the mediator expects will be incurred. 2. During the course of mediation proceedings, the mediator may direct supplementary deposits in an equal amount from each party. 3. If the required deposits are not paid in full by both parties within 30 days of the direction, the mediator may suspend the proceedings or may make a written declaration of termination of the proceedings to the parties, effective on the date of that declaration. 4. On termination of the mediation proceedings, the mediator shall render an account to the parties of the deposits received and shall return any unexpended balance to the parties.